Good morning. Happy hump day. So, Lane Myers is, he should really ask the law office of Lane Myers channel to do a video giving legal advice to pro se litigants on how and when to recuse judges. Yesterday I made a short video. I don't think I really laid it out well so people could really understand what's going on. In the Arizona Code of Criminal Procedure, there are a few circumstances under which the defendant or the prosecution can, as a matter of right, get a different judge to hear their case. Lane Myers filed a motion. It's called recusal. At least in California, it's called recusal. In most places, it's called recusal. I didn't see that language in the Arizona Code of Criminal Procedure, but it's a recusal. It's just saying this judge can't hear this case. One of the common things to do is if there's some sort of bias, and the judge will, generally speaking, be smart enough to recuse themselves. If they aren't aware of the bias, like, oh, hey, you actually had dinner last year with the defendant. So there's bias there. There's apparent bias. So, I didn't remember I had dinner with him, but I'll go ahead and recuse myself. You file a motion. But there are times when you can do it as a matter of right. Just because you want to, because you feel like it, because you don't like the way the judge rules or whatever reasons you have, you can just do it as a matter of right. So Lane Myers, was it yesterday, I think? I saw it yesterday. He filed a motion, actually filed it on the 6th of July, claiming as a matter of right the opportunity to recuse Judge Griffin. Now, the rule that he chose to proceed under, because it's a very small subset of rules, was you could do it as a matter of right within 10 days of getting actual notice that the judge you want to recuse has been assigned to your case. And he alleged that the first time he had actual notice that Judge Griffin was assigned to his case was when he received a document from the court on June 28th. Now, the document was dated the 26th. It was file stamped on the 26th, but he alleges he received it on the 28th. So he filed his motion for recusal on the 6th, which is 8 days after he allegedly got actual notice. And, 10 days after the document, the notice was sent. So he filed it within the prescribed time, the 10-day window that he gets under that particular rule of criminal procedure. So it looked good on its face, but I remember things sometimes, occasionally. And I remembered that in Lane's motion to modify his probation conditions, he named a judge. I'm like, well, what judge did he name? Because I forget the other judge's name. I'd remember it if I saw it, but anyway, like it was like Metcalf or something like that. I was like, what did he name the judge who did the sentencing and took the plea, or did he name a different judge? So I went back and I looked because I remembered he put a judge's name on it, and it was Judge Griffin. And he filed his motion. He signed his motion on June 12th. He filed it, or it was filed on June 14th. So obviously 10 days from June 14th would be June 24th. So he missed the 10-day window. And I made my video yesterday, if a guy like me, just some podunk California attorney wearing Hawaiian shirts or cowboy shirts, sitting in a car with kid seats in the back, if I remember these things, I'm pretty sure the DA is going to remember it. And lo and behold, she filed yesterday at around 4:30 or 5 o'clock. She filed an objection to his recusal, noting the very thing that I noted, that on his original moving paperwork, he identified Judge Griffin as the judge. So what's going to happen? Well, the judge has no obligation to recuse himself at this point. Myers missed the 10-day window. He doesn't have it as a matter of right. Could the judge still recuse himself? Sure, could. I mean, maybe he doesn't want to deal with Lane Myers, pro se litigant. The judge has reappointed the attorney who was assisting Myers. I'm sure that attorney is not particularly thrilled with it, to represent Myers on his motion to modify probation conditions. And Lane Myers can still proceed pro se, but then I think the attorney's name is Resnick or whatever, something like that. That attorney still has to be present as elbow counsel. But so here's first of all, Lane Myers might have made a bad tactical decision. Sometimes it's appropriate to recuse a judge. There is an attorney who I do a lot of work for who will always recuse a particular judge out of Placer County who hears family law cases because this attorney doesn't think that judge likes him and will rule against him and his client on things where the judge has discretion to do it. I don't think that's the case, but this attorney feels that the judge is biased. So every time he gets that judge assigned to one of his cases, he will automatically recuse that judge. Just every time, all the time. And the judge will just accept it. He doesn't want to deal with this particular attorney anyway, probably. But there are times that you might want to do it. Like if you're a defense attorney and a particular judge gives harsher sentences, you might automatically recuse that judge. There are tactical reasons to do it. But there are also reasons why you might not want to do it. And one of the reasons why you might not want to do it is because if your motion to recuse isn't successful, judges are people, and as much as they might try to be unbiased, they're people. They're humans. They have human emotions. And trying to disqualify a judge might have a negative impact on the way that judge is going to rule. That doesn't mean the judge is going to automatically rule against you. But on wobblers, on things where it could go this way or that way, the failed recusal attempt might just be that little extra, straw that's going to break the camel's back. I'm not saying it will, but it could. Now, I've already said that assuming the allegations made by the district attorney are true, and assuming that probation comes to similar opinions as the DA, Myers already had a long road to hoe. Very unlikely that his motion to modify probation was going to get granted, just out of the gate. He just has the personality where he just is like a little chihuahua just barking, yap, 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 yapping. You look at just go to Lane Myers nonviolent whatever YouTube channel, not the law office of Lane Myers, but his normal YouTube channel, and look at all the videos on there. You look at the, you don't have to watch the videos, just look at the thumbnails that he chooses. Every single thumbnail is intended to aggravate, harass, whatever. Now, I'm not saying that is like actionable in and of itself, but the judge is going to have to make a decision on, is this guy the kind of guy that I could relax the probation conditions on? Is he unlikely to reoffend? Is he unlikely to go after the victim again? He's asking to have that restriction taken off of him, but is he going to be the kind of guy who can cover the victim in a fairly unbiased fashion without putting her face up on, I'm going to say humiliating AI generated screen grabs. I mean, look at the picture he did of me on his last live stream. It has a giant Lane Myers and a very small me. Now, I'm 6'2" and change. I'm not a small guy. At my heaviest, I was about 250. Right now, I'm about 200 because fat boy's trying to lose weight. But I'm not a small dude, and I'll bet I'm bigger than Lane Myers. But that's what he does. He just tried, like, he put up Judy with like a gremlin kind of thing with a dong pointed at her mouth. Like, is this the kind of guy who is not going to then try to start harassing the victim again? So he had a long road to hoe. I mean, very unlikely to succeed. I don't think probation, he's got to realize that, like, probation is watching his channel. The victim is watching his channel. The DA has probably looked at the channel. I have a nut stuck in my tooth. Almond. Lightly salted. I put salty nuts in my mouth. Anyway, so unlikely to succeed. But having Lane Myers, the law office of Lane Myers, representing the pro se litigant Lane Myers, having that guy do the motion, first of all, was not a smart idea. Him representing himself at the hearing, I mean, at this point, because of all the actions he's taken, I mean, very low odds of success anyway. But at this point, damage control is really the name of the game. Mitigating the damage or trying to argue around the evidence that the DA is going to present in an effort to tighten or revoke probation, that's really the name of the game at this point. Like, he went from the offense. Now he actually should pivot to defense. I'm not giving him legal advice. The legal advice I'd give him is to hand everything over to your attorney and let your attorney do it. I said, and he took great offense to this, I said Chili DeCastro is smarter than Lane Myers, which again is not suggesting at all that Chili DeCastro is smart in any way. I'm not giving Chili DeCastro a compliment. I am making a negative assessment of Lane Myers' intellect. Not because he might have had some success on a lawsuit. An idiot can win a lawsuit if all the facts and evidence are in your favor. An idiot can win a lawsuit if you can get the other side to make you a settlement offer. Like, that's not the metric. The metric is in understanding your own limitations. And Chili DeCastro does it better, and I can tell you why. It's because after he failed in the Las Vegas criminal case that he lost and then appealed, he had an attorney represent him. He's hired an attorney to represent him in the Oklahoma criminal case. In the lawsuit against LVMPD, he eventually hired an attorney. He realized that any odds of success that he has are going to be better with an attorney. Now, he still lost, but that's just the facts. I mean, there's not a lot an attorney can do if the facts and the law are against you. And a jury looked at everything and said, meh, sorry. But his odds of success were better with an attorney. Your odds of success are better with an attorney. And Lane Myers doesn't get that. Attorneys are professionals. This is what we do for a living. You might not like it. You might not like us. There's a lot of attorneys who are very unlikable. I'm probably one of them. But this is what we do for a living. We know the ins and outs. We know how to massage the facts to try to present them in a better light. We can give you advice on what to do next, on how to stop making videos that are fucking insulting to people, that are intentionally trying to egg these people on. Because if you're doing that, and at the same time you're saying you want to be able to make videos about the victim, What is the court going to assume? The court's going to assume you're going to make videos about her like you're making videos about everybody else. And like the videos that originally were the issue. Now, Lane Myers always forgets that it wasn't just the videos that were the issue. Oh, it's my free speech. Well, you went to her office. You know, it's like I don't care. He called me again yesterday. I didn't answer the phone in time. It was ringing for like maybe 10 seconds, and I looked, and I'm like, who is this? And then it hung up. But then I looked through my log, and I saw that it matched up with the other 2 times he called. But like, if someone doesn't want to talk to you, Lane, it could be harassing to go to their office, to their place of employment, and try to ambush them. It's definitely harassment to instigate people to call. You know, again, I don't care. The only person who's called me since Lane's put up my number, that I'm aware of anyway, the only person that's called me after Lane put up my bar information, which I don't care about. I've put up my bar information before. I've said my bar number on videos. I've said my name on videos. It doesn't bother me, but the only person who's called me is Lane. But him doing that kind of stuff, him putting up the contact information, is an attempt to get people. It's a blatant attempt. It's obvious to anybody like a judge that you're trying to instigate your viewers to contact that person, to harass them. And again, I don't care that you did it to me. I don't care. Whatever, dude. I'm a big boy and I wear big boy pants, and it doesn't bother me, but it does bother some people. Like, it bothered the victim. And you went to her place of employment. And you actually got people to call her and to harass her and to send her threatening letters. And your associations with those other 2 guys got them to make videos that also caused people to harass her, or allowed people to harass her, disseminating her information for the intention. It's not just your videos, it's all of your conduct. And if you talk to an attorney could have explained that to you. Not that you're smart enough to understand it, but an attorney could and would have explained it to you. Resnick could have explained it to you, or I think his name is Resnick. Anyway, I've babbled long enough. Good luck to you, Lane Myers. I don't actually have any negative feelings towards you. My assessment that you're a retard is not based on any dislike I have towards you. It's based on observing your behavior, observing what you've done. You not being smart enough to realize that you need an attorney. You persisting in attempting to file junk motion after junk motion. I get it. I was in jail. It's hard to do while you're in jail. Yeah, well, you know what? If you hadn't done the dumb shit that got you in jail in the first place, if you'd relied on counsel to try to get you out of jail, if you'd allowed counsel who wasn't in jail to do the motion work for you, it's like all of this shit is of your choosing. All of this shit is of your doing. You are responsible for all of it. So when I say you're a retard, it's not because I dislike you. I find you to be quite entertaining the few times that I've watched you, when you're not just playing music on your screen and not doing anything, but when you're spurging out, you're quite entertaining. But you're not smart. And one of the hallmarks of being smart is realizing your own limitations. Like, I don't go and try to give medical advice because I'm not smart enough. I don't know anything about being a doctor. I mean, I could fake it on declarations, but like I would never give anybody medical advice. You got to be smart enough to know your limitations, Lane. Your limitations are you're not an attorney. Yeah, you've read some criminal procedure and you've managed to wrangle a Westlaw subscription, But that doesn't make you smart. Having access to information doesn't mean that you have the ability to understand the information, to filter it, to identify key issues, to distill from an opinion a rule of law that you could then cite to without it being dicta. Dictum damn near killed him. Anyway, thanks for watching. Have a great day.